Welcome to the second in a series of videos meant to familiarize journalists with the procedures in Kansas state courts. This video is published by the Kansas Bar Association's Media Bar Committee with the goal of helping build mutual understanding among Kansas journalists, judges, and attorneys. Now, in the last video, we talked about the beginning steps in a criminal case and how to obtain a probable cause affidavit. This video will discuss what happens up to the time of trial and at trial in a Kansas criminal case. Keep in mind that a criminal charge is brought by the state of Kansas, or in the case of a municipal court case, the city, against an individual defendant. The pretrial exchange of information between the state on one hand and the defendant on the other is sometimes referred to as the discovery process. When a person is charged with a crime, they have the right, by Kansas statute, to obtain copies of the prosecution's file, including any statements or confessions, results of tests or examinations, and other documents that are important or material to the case. Under the U.S. Supreme Court's ruling in Brady v. Maryland, any exculpatory evidence that would tend to show the defendant is not guilty of the crime, must be turned over. Prosecutors are also entitled to some defense materials, including expert testimony and documents that may be used at trial, which do not create an unreasonable burden on the defense. Even though a person cannot be charged with a crime in the first place without probable cause, a preliminary hearing is an additional step in Kansas felony cases that tests the state's allegations early in the case. A preliminary hearing is where a judge determines if there is probable cause to believe the defendant committed an alleged felony, viewing evidence in the light most favorable to the state. In other words, resolving any conflicting evidence or testimony in favor of the prosecution. It is a right created by Kansas statutes as opposed to a constitutional right, and is available to anyone charged with a felony. The state also has the right to a preliminary hearing. At the preliminary hearing, the state presents evidence, and the defendant may too. Importantly, the defendant has a right to have an attorney and to cross-examine witnesses. It is often the public's first chance to learn the details of the prosecution's case. It is not uncommon for defendants to waive their right to a preliminary hearing. If a judge finds probable cause, the case is set for trial, sometimes referred to as the defendant being bound over for trial. Leading up to a trial, either before or after a preliminary hearing, there could be various motions filed by either side. A motion just means a request to a judge to make a certain ruling. The judge may or may not hold a hearing on the motion for both sides to argue their case. Some pretrial hearings are just scheduling conferences, where both sides discuss the progress of the case with the judge and set deadlines. Other pretrial hearings may be specific to one issue, such as a hearing on whether certain evidence will be admissible at trial. This could include a motion to exclude any evidence that a defendant claims was gathered in violation of the Fourth Amendment right against unreasonable search and seizure, or what's known as a Jackson v. Deno hearing, named after a 1964 U.S. Supreme Court case to decide whether a confession by a defendant was voluntary and therefore admissible as evidence. If a case involves testimony by experts, the parties might argue over whether the expert is allowed to give certain testimony. Leading up to a trial, both sides typically file motions in limine, which aim to keep out certain evidence or testimony at trial under the rules of evidence. In high-profile cases, a defendant may file a motion to change venue, arguing that they can't get a fair trial in the district court where the case has been charged. In that situation, the defendant needs to establish that there's been prejudice to the defendant's right to receive a fair trial in the district court where the case is pending. Those arguments can be based on the Sixth Amendment constitutional right to a fair trial or on the Kansas Constitution. But it is important to know media publicity alone is never enough, in and of itself, to show prejudice to the defendant's right to a fair trial. It's important that the case proceed in a way that protects the defendant's constitutional rights, including their right to be free from unreasonable search and seizure under the Fourth Amendment. the right to due process under the Fifth Amendment, and to a speedy public trial and impartial jury under the Sixth Amendment. Many pretrial rulings have the potential to create issues for a higher court later if the defendant appeals their conviction. At the same time, courts recognize that the Sixth Amendment includes the public's right to observe judicial proceedings. A landmark 1981 ruling by the Kansas Supreme Court, Kansas City Star v. Fossey, holds that a pretrial criminal hearing in Kansas cannot be closed unless the judge makes specific findings on the record that keeping the hearing open will create a clear and present danger to the fairness of the trial, and that there is no reasonable alternative to closing the courtroom. In some cases, a judge may place limitations on what the parties can and cannot say about a case, above and beyond what's required by the ethics rules. However, a gag order that seeks to prevent journalists from reporting what they learn in open court is an unconstitutional prior restraint under the Kansas Supreme Court's 1994 ruling in State v. Alston. Kansas courts have a special rule, Supreme Court Rule 1001, allowing for electronic media coverage of court proceedings. In general, the rule is that using a camera or recording device, even a cell phone, during court must be approved by the judge in advance. The rule says a request must be made 7 days in advance, though the judge can waive that requirement. The judge has a lot of discretion on what to allow, for example, whether to allow live posting of reports from the courtroom. So it's best to clear up any issues ahead of time. Most people know the term plea bargain or plea agreement from television or films. A plea agreement can take many forms, but at its core, it's an agreement between the state and the defendant, whereby the defendant and state exchange something of value. Typically, this will be the defendant agreeing to plead guilty to a lesser crime or to testify against another party in exchange for the state dropping or reducing charges or recommending a certain sentence to the judge. It's important to note a plea agreement is only an agreement between the state and the defendant and must be accepted by the judge. For a defendant to be allowed to plead guilty, the judge must establish the factual basis for the plea, hearing directly from the defendant that they committed the charged crime. The judge is not bound by the plea agreement and may impose any sentence allowed by the law. There are various strategic and other factors to consider in plea negotiations and can depend greatly on the severity of the underlying crimes. A plea agreement can be reached at any time before the jury returns a verdict. Under Kansas statutes, prosecutors have an obligation to inform victims about the status and outcome of a case, including any plea agreement. In Kansas state courts, all plea discussions, at least for those involving felony cases, take place with the state's criminal sentencing guidelines in mind. The Kansas sentencing guidelines were created in 1993 to provide more uniformity in sentencing criminal defendants. The sentencing grid takes into account the severity of the felony charged, with a level 1 felony being most severe, and the defendant's criminal history, scored from A, the most serious history, to I, the least serious. The combination will land them, bingo-like, in a box on the sentencing grid. This will show the presumed length of the sentence for a crime, shown in months, and whether there is a presumption that time will be served in prison or on probation. Prosecutors may agree, for example, to drop a level 4 charge and reduce it to a level 6, and to not oppose a request for probation. A plea agreement may include a request for a downward departure, that is, for a judge to treat the crime as if it falls lower on the sentencing grid. To make a deviation from the sentencing guidelines, a judge must find that there is a substantial and compelling reason to depart from the guidelines. The legislature has determined that a few crimes are so abhorrent to society that they merit an off-grid sentence, including for murder and child sex crimes. A typical sentence for an off-grid crime is 25 years to life or 50 years to life for first-degree premeditated murder. In some cases involving premeditated first-degree murder, prosecutors can seek the death penalty. Those cases include premeditated murder committed during a kidnapping or rape, or of multiple victims, as well as killing of a law enforcement officer. As of the summer of 2024, Kansas had 9 inmates sentenced to death. However, the state has not conducted an execution since 1965. At the end of the day, defendants who do not reach a plea agreement will have their case set for trial. Unless they waive it, the trial needs to be held within the speedy trial time frame discussed in our prior slideshow. At trial, the state needs to prove each and every element of the crime charged beyond a reasonable doubt. If there is conflicting evidence, for example, a defendant claims to have acted in self-defense, juries get to decide which evidence and facts they find more credible and whose version of events they believe. The judge gives the jury detailed instructions about the law and asks that they apply the law to the facts of the case and reach a verdict of either guilty or not guilty. Names of potential jurors are drawn at random from registered voters in the community, along with the driver's license information in some counties. If you've ever been called for jury duty, you know that only a small fraction of those called to the courthouse actually end up serving on a jury. By definition, the court calls many more prospective jurors than it actually needs. That's because during the jury selection process, many people will be eliminated during the process of questioning potential jurors, known as voir dire, or meaning to speak the truth. Jurors can be dismissed either for a hardship, such as medical issues or family concerns, or because they can't be impartial. For example, they may know a participant in the trial. The court usually stops with jury selection when it's reached a large enough group of jurors who don't fall into those two categories. The state and defense then each get to eliminate an equal number of jurors for strategic reasons, leaving a jury of 12. There are also usually a handful of alternate jurors picked to sit in on the trial in case one or more of the members of the jury can no longer serve. Once all of those pretrial issues have been resolved, the trial begins with some initial jury instructions, followed by opening statements by the prosecution, then the defense. An opening statement is meant to be a summary of the facts that each side believes it will be able to prove at trial. The state then calls its witnesses in what's known as the state's case in chief. In other words, it's evidence and testimony that the state is putting on first to meet its burden, as opposed to evidence being used in response to testimony put on by the defense. The state puts on whatever evidence it thinks is required to prove the elements of the crime beyond a reasonable doubt. Courts have refused to define that term further, leaving it up to the jury in each case to determine exactly what it means under the facts of the case. You've heard the saying, "I rest my case." Once the prosecution has put on all of the evidence, it does just that, with the prosecutor literally telling the judge the prosecution rests. Often the defense will then move for a directed verdict, arguing that prosecutors have not put on enough evidence to prove the element of the charges. This is typically done outside the presence of the jury. If the charges are not dismissed by the judge, the defense can then put on its own evidence, if it chooses to do so. Under the Fifth Amendment, no criminal defendant can be required to testify, so it's often unknown to anyone but the defendant's legal team whether a defendant will take the stand as a witness. Following the defense case, the prosecution has a chance to put on rebuttal evidence. Then the court reads a set of detailed jury instructions drawn from Kansas law, which tell the jury how to apply the law to the facts of the case. Finally, both the prosecution and defense make their closing arguments, explaining why they think the facts show that the defendant is either guilty or not guilty under the law. The case is then submitted for the jury's consideration. A jury verdict can take minutes, hours, or days. A conviction on a particular charge requires a unanimous verdict of all 12 jurors. One juror voting not guilty leads to an acquittal on that charge. If jurors simply can't decide, no matter how hard they try, the court can declare a mistrial, leaving the state to decide whether it wants to try again to prove the allegations. However, a defendant who is acquitted of a charge cannot be tried again under our constitutional protections against double jeopardy. You heard earlier about the sentencing grid, and while that is a big factor in what sentence a defendant will be facing, it's not the end of the story. The court will often have its staff prepare a pre-sentencing report that goes into detail about the defendant's criminal history, determining their official score under the sentencing grid, and detailing the expected or presumptive sentencing range, as well as any requirements for probation. It also contains the official version of what the defendant has been convicted of doing, any victim's statement or request for information, as well as the statements of the defendant if they choose to make one. Note that pre-sentencing reports are typically deemed confidential and not included in the court file. However, information from the report is often described in open court. The judge must also decide at sentencing whether to grant a request to depart from the Kansas sentencing guidelines. In other words, to impose a sentence different from that shown on the sentencing grid we looked at earlier. Sometimes either the state or a defendant will make a request for a departure. It's up to the judge to decide whether or not to grant that request. There are also a number of off-grid offenses, such as first-degree murder, a murder during the commission of a dangerous felony, or charges under Jessica's law for certain sex crimes involving young victims. In those cases, the judge will impose a sentence based on the range of penalties listed in statute, but not on the sentencing grid. When the defendant appears for judgment, the defendant must be informed by the court of the verdict of the jury or the finding of the court, and ask whether he has any legal cause to show why judgment should not be rendered. If none is shown, the court shall pronounce judgment against the defendant per KSA 22-3422. The defendant has an opportunity for allocution, or letting the judge know whatever information they think the court should know about their crime. For example, sometimes defendants use allocution to ask for a lenient sentence or to apologize to a victim's family. Victims also have the right to be present and often have a chance to address the judge. By statute, victims are entitled to notice of things like requests for a downward departure from the sentencing guidelines. A defendant convicted of a crime has 14 days from sentencing to file a notice of appeal with the district court. The defendant can appeal various rulings by the trial judge, such as a ruling to admit certain evidence, as well as claimed errors by the prosecutor, juror misconduct, or errors in the sentencing, to name a few. For example, in recent years, convictions in Kansas courts have been overturned for a judge not allowing a defense attorney to finish a closing argument, a prosecutor making prejudicial statements about the defendant in a closing argument, and facts about a defendant's past crimes being improperly allowed into evidence. Separate from a direct appeal of their convictions or sentencing, a defendant might also file what's called a collateral attack on their conviction by filing a civil action under KSA 60-1507, claiming they're being illegally detained in violation of the Constitution or laws of Kansas. This is also known as a petition for a writ of habeas corpus. A typical reason for these cases is the defendant's claim of ineffective assistance of counsel. In those cases, the judge must decide whether the defense attorney's actions or lack of actions undermined the proper functioning of the trial process, leading to an unjust result. A habeas claim of ineffective assistance of counsel may only be brought after all other appeals on the merits of the case have been resolved. We want to thank you for taking the time to view this slideshow, which we hope is helpful as you seek to inform the public about the role of criminal courts in our legal system.